Wait a second, 2012? That's over a decade ago. We're talking about an alleged offense that predates TikTok, pandemic courtrooms, and even the iPhone 5. Right off the bat, this case is about one thing: time. And in the courtroom, time isn't just a number, it's a constitutional right.
This offense date was June 1st of 2012. That's 11 years and 4 months before Mr. Hinojosa was arrested.
We're here on a motion to set aside the indictment based upon failure to afford and violation of constitutional right to speedy trial. State, have you reviewed that motion?
Yes, Your Honor, I have.
All right, and are you prepared to proceed?
Yes, Your Honor.
All right. Defense?
Yes, we're ready, Your Honor, and I've outlined the relevant timelines in the motion itself. And if you'd like, I can outline those. I
Yes.
believe that once I do outline those timelines, the burden would shift to the state. And I believe, and I don't want to speak for the state, but I believe they have one witness to put on.
All right. Then if you'll outline your reasons.
Your Honor. Briefly, the timeline before the court, and it's all available to be verified on the Bexar County information system that's available to the court. This offense date was June 1st of 2012. That's 11 years and 4 months before Mr. Hinojosa was.
Under the Sixth Amendment, every defendant has the right to a speedy trial. The longer the delay, the more suspicious it looks. The defense is clearly setting up a Barker versus Wingo argument. That's the Supreme Court case that basically says, if the government drags its feet too long, the whole case might collapse.
Arrested on this charge. If you look at those dates that are outlined, there are two relevant dates, both of them multiple years at a time. From the offense date to the action that the state took in August of 2017, that's a 5-year delay.
Mm-hmm.
From August of 17 until his arrest on this indictment is a 6-year and 2-month delay. And I'm not even including the 3 months between his arrest and today's date, which that's an additional 3 months. Your Honor, believe that the length of those delays taken together or even individually is so prejudicial that it affects our ability to put on a defense in this case in violation of the United States Constitution, Confrontation Clause, and the Barker v. Wingo case, and as outlined in the motion, and also the Article 1, Section 10 of the Texas Constitution.
And this is where the tension starts to simmer. The defense isn't just poking holes, they're lighting the whole procedural rulebook on fire. You can feel the courtroom shift. Everyone's wondering if 11 years of silence just killed this case before it even starts.
I'm not sure what evidence the state has that can surmount those prejudicial delays, but that is the relevant timeline, Your Honor.
All right, State.
Your Honor, I have one witness and I have arguments. You want to hear from the witness first?
Yes.
Okay, Your Honor, state calls Deputy Angela Alvarado. So.
All right, if you move this way.
Oh, sure. I'm over here.
Right in the middle, Judge?
Yes, thank you.
Is that okay if I'm right here, Judge?
Yes.
Okay.
Can you raise your right hand for me, please?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Deputy Angela Alvarado.
All right. So everyone, you all need to whisper. If you can't whisper, then you need to confer outside. All right, State.
Hi, Deputy. So did you attempt to make service of a warrant in this case?
Yes, sir. It
And-
looks like the first attempt was January 23rd of 2019.
Okay, and then did you attempt to serve that warrant on another date as well?
2 days later, sir.
Okay, and so on January 23rd, 2019, where did you go to serve the warrant?
The address I have,
Okay, and did you have any interaction with anybody there?
I noted that I spoke with the uncle.
And but were you able to serve the warrant on the defendant, Mr. Hinojosa, at the time?
No, I was advised that he didn't live at that location.
Okay. And so what happened a couple days later on January 25th, 2019?
I went to a secondary address on that date, his work address.
Okay. And were you able to serve the warrant on that date?
No, sir. I was advised that he used to work there, but quit the year before.
Okay. And did you try to serve the warrant before 2019 in 2017?
No, sir, that would not be me.
Okay, that was a different deputy.
Right.
So you were unable to serve the warrant on Tristan Hinojosa, but you attempted to serve it on January 23rd, 2019 and January 25th of 2019.
Yes, sir.
Okay, I pass the witness, Your Honor.
All right, defense.
Your activity in this case is limited to those 2 days in 2019, correct?
Correct.
This is the moment where the defense suddenly goes in for the kill. 11 years and no substantial follow-up? In legal terms, that's not just a delay, that's negligence. It raises one of the biggest questions in any delayed prosecution. Did the system fail, or did the suspect vanish?
Did you take any other action in these 11 years and 4 months between the alleged offense date and his arrest in this case?
Just beside the two dates listed on the warrant itself.
And those 2 dates were almost 2 years after the indictment, correct? A year and a half? Your 2019 attempts?
Okay. I'm not sure when.
I'm sorry, I didn't mean to interrupt you.
No, I'm not sure when the date of when he was arrested. Is that what your question was?
No, indicted.
Oh, indicted. I'm sorry.
Okay. You're not sure of the
No,
date?
no, sir.
Pass the witness.
No other questions, Your Honor.
All right. Is this witness excused?
Yes, Your Honor.
All right, thank you.
Thank you.
Thank you.
Defense?
Uh,
I'm sorry, state any further questions?
I just have argument, Judge, at this.
I'm sorry, any further witnesses?
Oh, no, Your Honor.
It's Monday for me.
Yes, ma'am.
Okay. All right, then the court will hear argument. Defense, it's your motion.
Yes, Your Honor. If you look at the Barker v. Wingo factors as the courts apply them in the state of Texas, we need to look at the length of delay. I think in this case that all the parties can reasonably agree that that is a tremendously long amount of time in this case, both between the alleged offense date and the indictment, and then between the indictment and when there was any activity on behalf of the state, whatever attempts those were in 2019, and then again between 2019 and the state's I just say weak attempts to find Mr. Hinojosa and 2023. Any of those taken individually are presumptively prejudicial, but taken together, it highlights the exact reason that these laws are on the books, Your Honor, and it prejudices Mr. Hinojosa's ability to put on a defense. I don't believe the state's efforts to show diligence in this case rise to the level of certainly it can't overcome the negligence that's apparent from the file. And for that reason, we ask for you to grant our motion to set aside the indictment.
All right. In your motion, it states that the case was dismissed July 28, 2017, and then re-indicted the same case on August 22nd, 2017. Why was it dismissed?
From my research into the JE system, it looks like it was originally supposed to be a theft, and the statute of limitations would have run on the theft by the date that it was the case was received from law enforcement by the DA's office. It was initially dismissed as a theft, but then indicted as a misapplication of fiduciary responsibility, which is within the statute there, Judge.
Okay. All right. State?
Yes, Your Honor. So because the length of the delay was over a year, the Barker case says the court has to consider the other factors. So just a little bit more clarity on the cause of the delay. The case was indicted on August 22nd of 2017. The prohibited conduct in the indictment is from June 1st, 2012 through June 6, 2013. So it's a little bit longer because of the prohibited conduct, a little bit.
Now here's where the story takes a twist. The prosecution says he was a fugitive for 6 years, basically, that he was hiding out. But was he really? Or did no one tell him he was wanted? What do you think? Is ignorance an excuse, or is it just convenient timing? Let's hear your thoughts below.
Less of a delay, rather. The defendant was a fugitive from 8/22/2017 through 10/21/2023.
Wait, I'm sorry, 8/22.
I'm sorry, yes, ma'am. 2017 when the case was indicted through 10/21/2023. We believe that's when he turned himself in once the case, when he turned himself in, Judge. We heard testimony from Deputy Alvarado that BCSO tried to serve the warrant on January 23rd of 2019 and January 25th, 2019. I don't have a witness to support the previous service date that was in 2017, but I can represent to the court. The notes from the MOCA system indicate that BCSO did attempt to serve the warrant in August 21st of 2017. So there were 3 different attempts to serve the warrant, Judge. The motion for speedy trial was not filed until November 30th of 2023. And the position of the state is that the defendant had not avoided service of the warrant 3 times. He would have been able to assert his right earlier. The defendant has to show that there was prejudice, Your Honor. Since it's over 4 years, the Barker case says that the court can assume there's prejudice. The state's contention is that the cause of the delay was the defendant's avoidance of the warrant. So I think the type of delay that the defense is claiming here is that their defense is impaired by this delay. But if the cause of the delay was the defendant's avoidance of the service, I think you shouldn't reward that, Your Honor. And there's a case, Dragoo v. State, which is a CCA case from 2003. And the holding in that is that the defendant acquiesced in the delay by avoiding service to the subpoena, Judge. So that's the state's contention, Your Honor.
All right.
I see that you denied the motion.
All right. And defense, it's your motion, so I'll give you a final argument.
Well, just briefly, Your Honor, there's no evidence before the court that he avoided anything. There's no evidence before the court on reference to a 2017 attempt to serve a warrant according to notes. And I just, as an officer of the court, and I've spoken to Mr. Wilkins, he and I discussed that entry, and that entry into their MOCA system, as he described it, is problematic. So I'd ask the court not to consider that. And again, Your Honor, I think the characterization that he's avoided service is inaccurate.
All right. And then the dates where they're saying he's a fugitive. I know sometimes people say fugitive, but nobody knows that there's a pending case. So for the dates, August 22nd, 2017 through October 21st, 2018, state when you said he was a fugitive, is that just a matter of there's a case in existence, either he knows about it or he doesn't know about it, thus he's a fugitive?
Yes, ma'am.
Okay. All right. Is there anything else from either side?
No, ma'am.
No, Your Honor.
All right. So if you all will be back at 10:30, I'll let you know what my decision is.
Thank you, sir.
Thank you. The court is back on the record in 2017, CR 9236, State of Texas versus Tristan Hinojosa. Can our parties re-announce for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
Sam Locke for Mr. Hinojosa.
And are you Mr. Hinojosa?
Yes, Your Honor.
All right. So to both parties, I heard both parties' arguments. I always try to internalize everything. And I understand that in this case, there are probably complainants that are owed restitution, right? But at the same time, I have to look at the defendant's rights, that complainant's rights to have their restitution or be made whole, or for somebody to try to make them whole. And Mr. Wilkins, I know that this case did not originate with you, but the court has a hard time getting past the fact that the offense occurred on June 1st, 2012. Here we are in 2024. He was detained on that offense on June 1st, 2012, according to the defense's motion. Then he was released. Then a grand jury number was assigned in May 26, 2017. Then the case was dismissed July 28, 2017. And I understand the reason for the dismissal was because potentially the statute of limitations had run on the specific.
And here comes the payoff. The judge isn't buying the idea that this man was just unfindable. She's seen too many cases like this. The paper trail doesn't lie, but sometimes the effort does. When she says investigators could have easily found his employment or residence, that's courtroom code for the state dropped the ball.
Offense. But then he was re-indicted on August 22nd, 2017. And then the warrant was issued. The officer testified that she went to what she believed to be his address, spoke to an uncle, not him, and the uncle said he doesn't live here. And it doesn't appear from any witnesses that there was more investigation into his residence. Then the officer said she went to the employment and they said he doesn't work here. And then there seems to be no further investigation into his employment, which it's my belief, because I've had investigators do this before, it's easy to find where somebody's employed at. There's an entire system for people to look on the computer to find out where somebody has been employed. There's an entire system to look to find out where somebody, where their residence is. And she's saying that the uncle, she left a message for the uncle to get in touch with him, but I don't have any evidence before me that the uncle actually got in touch with him. So for those reasons and many other reasons, I am going to grant the defense's motion. Is there anything else?
No, Your Honor.
No, Your Honor.
All right, thank you.
And there it is, motion granted. The indictment is tossed. After 11 long years, justice doesn't come through punishment, it comes through procedure. Whether you agree or not, that's how constitutional law works. If the system waits too long, the system loses.